Hi, good afternoon, everybody, and welcome to the IOSH Southwest legal update. Also welcome those members from different networks all over the UK. Normally, before legal updates, we would have our AGM, but given the time of year, we will hold back on the AGM until next year. So I only have two names to introduce to you today. Firstly, myself, I am James. I am the chair of IOSH Southwest. And we have John Cooper from Womble Bond Dickinson, who will be presenting the legal update this afternoon. For those of you who used to attend our seated events, you'll recognize John as one of our regular contributors. And for those of you that don't know John, John heads the health and safety team at Womble Bond Dickinson and has long been recognized as one of the leading health and safety lawyers. John and his team have been involved in most of the major investigations over the last few decades. And in Chambers, which is the leading guide to the legal profession, it's been said that John is a veritable doyen of health and safety solicitors. He's generally acknowledged to be the leading health and safety solicitor in the country. So after that substantial introduction, all I have left to say is that this webinar will last around 45 minutes, and there will be approximately 10 or 15 minutes at the end for questions. But if you do think of a question beforehand, please post it in the Q&A box at the bottom of your screen, and we'll try, if time permits, to ask it at the end. So John, it is over to you.
Thank you very much, James. I hope everyone can see my presentation now. Thanks very much for the opportunity to speak to you today. What I'm going to cover is in the slide there. It's recent cases, what's coming over the health and safety horizon, and inevitably, and I hear you sigh, COVID-19. But what I'm hoping to do in relation to that is to give an insight as to how what is clearly a public health issue has impacted on health and safety in the workplace. And I'll express some views on that which may or may not meet with your agreement, but may well, I hope, lead to some questions and some debate. So starting with cases, first case I wanted to mention was a case decided a few months ago in Nottingham Crown Court. And it's prosecution brought by the ORR against Renown Consultants Limited, trading as Renown Rail Services. Charges were breaches of Section 2 of the Health and Safety Work Act, which is the, as you'll know, the duty to ensure, so far as is reasonably practicable, health, safety and welfare of employees, and a failure to carry out a suitable and sufficient risk assessment, contrary to Regulation 3 of the Management Regulations. The facts were quite straightforward and not really disputed. Two employees of Renown were sadly killed in an RTA as they returned home in the small hours of the morning after carrying out welding work on the railway. One of the employees fell asleep in the car they were travelling in and it crashed, sadly resulting in 2 fatalities. As is often in the railway sector, they'd been working in a fairly remote area and there was a significant journey upwards of an hour to and from where they were working. Prosecution was brought on the basis that there was a failure to carry out a suitable and sufficient assessment as to the risk and potential consequences of fatigue arising from those particular circumstances, namely that employees had to drive long distances to and from their place of work. Defence case was that the prosecution was that the prosecution was misconceived, but the jury disagreed and the company is convicted on both counts and fined £450,000. And I think the most interesting part is the judge's sentencing remarks, where he said that the greatest failure on the part of Renown was the failure to carry out a suitable and sufficient risk assessment on the day before the fatalities, which led to the company failing to comply with its own fatigue management procedures. One of the features of this case was that because there is so much, particularly in the railway sector guidance, it's been a drum that ORR has been beating for many years around fatigue, that they actually had their own policy which recognised the risks of fatigue. So on that basis, it was perhaps not surprising the jury took the view, well, as you've identified it as a risk, you should have done more to make sure that you controlled that risk. And you'll see there that the judge found in his sentencing remarks that the operations teams and the managers knew what they were supposed to do in relation to fatigue, but they paid lip service to those systems. And that all was reflected in Renown's attitude and willful failure of his own policies. It being a willful failure, it gave the judge the opportunity to use the phrase that was always an indication you're in for a serious kicking in terms of sentencing, and that the judge found it to be a systemic failure by Renown. There was quite a lot of debate about this case as to whether it broke new ground, in that some saw it as employers being held responsible for the act of third parties, i.e. the driver, when not on the work site. So what more could they do to control it? But I don't think that's right. I think it's about knowing that if you are requiring your workforce to travel distance to and from work, and because of the nature of the work, when it's carried out being at night, then you have to factor that into your arrangements. So, do you have less time on site? Do you have some form of local accommodation? These are all issues that can be dealt with. Wider implications, fatigue has been an issue in the railway sector for some years. It's gaining traction with HSE, and I think it's linked to some extent to HSE's increasing emphasis on mental health and well-being. So what the case will do, and it's a Crown Court case, so it's not binding, it's a jury decision based on the facts, but what I think it will do, it will encourage regulators to take a more robust view in relation to the management of workers who are working on site away from home and distance away from home. So quite an interesting case. The next one, first thing I draw to your attention is at Luton Crown Court. The next three cases I'm going to deal with are all at Luton. So one of the warnings there is if you're operating in or around the Bedfordshire area, you may well end up in Luton Crown Court. It seems to be a particularly vigorous health and safety enforcement regime around there. But this may be of interest to IOSH members in particular because it was a prosecution of a self-employed health and safety consultant. And the defendant, Mr. Wheel, gave advice particularly to SMEs on the management and control of risk in relation to halves, noise and COSH. His advice was inadequate, and he was charged with a breach of Section 3, which is a duty, as you know, to ensure, so far as is reasonably practical, that persons not in your employment are not exposed to risks to their health and safety. There have been an increasing number of prosecutions of consultants, and I think it shows an interesting approach from HSE. As you'll know, duties under health and safety legislation are not delegable. So if you operate a company and you employ a consultant to give advice, then you cannot rely on that advice to discharge your duty. What you can do is to say, well, we did all that was reasonably practicable, in that we made appropriate inquiries as to the competence of the consultant, and we had no reason to doubt his or her advice. But that is different from saying that you can delegate your advice, your duties to a consultant. Simply can't be done. I think what the case is, however, a recognition that employers should be entitled to rely upon independent advice. It's a reminder that organisations using external consultants need to exercise due diligence. You can't just appoint a consultant without making reasonable inquiries as to their competence. And as I said, employing a consultant, however competent on the face of it, is not necessarily a defence if the company is in breach of its own health and safety obligations. The public interest consideration point I make there is this: whenever a prosecution is brought, the prosecution has to be satisfied, firstly, that the evidential test is made out. In other words, that there is sufficient evidence for there to be a reasonable prospect of conviction. But once that evidence, that evidential threshold is met, they still have to be satisfied that prosecution is in the public interest. And in health and safety cases brought by the HSE, the public interest criteria are set out very clearly in their enforcement policy statement. And for local authority prosecutions, then they very often adopt those health and safety executive criteria. The point here is really that if there is clearly a reliance on a consultant, that the company doesn't have the expertise in-house to deal with issues, and as a result is in breach, it may well be in the public interest not to prosecute the employer, but to prosecute the person or organisation in whom the employer has put his trust, the consultant. And the wider interested point, of course, is that the consultant is likely to be offering consultancy services not just to that organisation, but to a number of organisations. So there is a much wider public interest in prosecuting the consultant as opposed to the employer who relied upon that consultant's advice. Next case, in May, again at Luton Crown Court. This is a very interesting case in terms of sentencing. Modus were convicted of a breach of Section 3, and the prosecution arose from an accident where an employee sustained serious but not life-threatening injuries in an accident in September 2016. And the accident happened when Modus was carrying out its general business, which is specialising in the conversion of buildings to office space and the fitting out of office space. They pleaded not guilty, were convicted by a jury and were fined £1.1 million. Now, as you may know, when sentencing, the courts have to apply the definitive guideline, which requires them to make findings of the level of culpability, ranging from very high to low, the level of the harm risked, which we level A at the top to level C at the bottom, the likelihood of that harm risk occurring, and that then arrives at a sentencing category, which is based on the organisation's turnover. Now, having gone through that exercise, the court has to decide upon its starting point, and then will increase the starting point if there are any it will increase the starting point if there are any aggravating features. For example, if the breach led to the injury, previous convictions and the like, and will then reduce it if there were mitigating features such as a previous good record. There is also other mitigation which the court has to weigh up and take into consideration. And in this case, in spite of evidence being put from the company's accountants and auditors as to the very substantial impact that the pandemic will have on its business, the judge took the view that the potential consequences of COVID-19 were speculative. Now, given that was in May, when we were at the height of the first wave, you might think it's quite an extraordinary approach to take. And what she said, well, if financial circumstances prove that more time was required to pay, the court will review that request with sympathy. But she refused point blank to take account of the if likely financial impact. And given that, I think latest statistics show that office occupancy has not gone back to more than 35% since the pandemic. It doesn't take a great deal of imagination to, and it's supported by evidence here that, well, the business model of an organisation which depends on office refurbishment and fit out is not looking rosy financially in the years to come, but didn't take it into account. The company, Modus, has appealed or sought permission to appeal against sentence in this case. And in fact, the Court of Appeal granted permission for an appeal against sentence to go ahead last week. And it is likely to be heard before Christmas. And I would expect that fine to be reduced. Now, in red, you'll see another case at Luton County Court. Luton Borough Council were prosecuted. Interesting case on the facts, in that it was a prosecution brought as a result of the failure on the part of the Borough Council to protect its teachers against violence from pupils. Pleaded guilty. The judge in that case decided that the level of fine should be reduced from 300,000 to 104,000, due largely to the council's lack of revenue as a result of the coronavirus pandemic. So an approach which is completely at odds to that taken in the Modus case. What makes that even more remarkable is that the judge in the Luton Borough Council case was the same judge as in Modus. So one of the problems we health and safety lawyers have in advising clients is lack of judicial consistency, and that's between judges. But where you have one judge taking a completely different view in October than she does in May, you begin to wonder where the world is going. Just another sort of insight into that. When you appeal to the Court of Appeal and you are granted permission by the Court of Appeal, the fact that a sentence is going to be considered by the Court of Appeal, notification of that is sent to the judge who imposed the sentence. So the cynic in me, and I hear you will shout, a cynical lawyer, surely not, but the cynic in me suggests that the judge may have been told in the early part of last week that the sentence she imposed on Modus was going to be subject to appeal, and therefore not wanting to blot her judicial career copybook too much, reined back when she sentenced Luton Borough Council on the 14th of October. we'll never know because that sentence won't be appealed, but I would be surprised if the Modus case does not succeed on appeal. It seems to me it's fundamentally wrong that there should be such a difference of approach in sentencing, and it's not taking account of what's going on in the real world. Right, that's a sort of canter through cases, and there'll be time for questions at the end, as James said in his introduction. So I'm just going to have a look at a few things which are coming over the horizon in terms of health and safety. And Grenfell and its aftermath continues to be a really dominant thread in the world of health and safety. And the latest sequence of events flowing from Grenfell is the draft Building Safety Bill, which was recently laid before Parliament. It was introduced as a result of Grenfell and the Hackett Review. As many of you know, Judith Hackett was the head of HSE for many years, and she was asked by the government to carry out a review. The basis of the review was that it was thought that there was a gap between the planning regime, building regulations, and wider health and safety. As you probably know, when you apply for planning permission, if it's granted, you get the permission, but it simply says the granting of planning permission does not obviate the need to comply with the existing building regulations, other health and safety legislation. But there's no sort of join up between the process. And that's a matter of concern, and this is what this bill is proposed to address. Stringent new proposed safety regime for higher risk residential buildings, HRBs, which are over 18 metres or 6 stories high. In effect, is an amendment to the Building Act 1984, and another key feature is a new regulator, which is the building regulator, which will, in all probability, be a branch or an agency of the Health and Safety Executive. So what's in the bill? I've listed the key proposals there. So there'll be new responsibilities for construction teams involved in new builds, and new responsibilities on landlords of existing HRBs. There are requirements to submit safety cases, and the legislation seeks to divide the building construction and management process into 3 gateways. The first is at the planning application stage, second, initial building control stage, and the third is the equivalent to the current completion or final certificate phase. And the intentions of the bill will require you to have addressed all health and safety issues at the gateway before you proceed to the next. So it's a system of ensuring that health and safety risks are identified, so far as it can be managed out of the process, but if not, appropriate measures put in place throughout the construction phase. It makes a great deal of competence, and there is provision under the bill when it becomes law for additional regulations to be brought in to establish the competence of those taking on work that needs to comply with building regulations. There's going to be a great more rigor about that. They're going to be mandatory occurrence reporting systems. This will cover any structural and fire safety occurrences that could lead to a significant risk. There are clearer sanctions. Wider use of compliance and stop notices during design and construction phase, together with the risk of prosecution, non-compliance with the bill when it's enacted, will be a criminal offence. The building safety regulator I mentioned is a new regulator, and it's the role of that regulator will be to oversee the safety and standard of all buildings. Second one I think is really interesting, to directly assure the safety of higher risk buildings. Well, that's a complete sea change in terms of regulation. Those of you who have sought advice from HSE will know that it always comes with the reminder that, well, it's your responsibility, and we can give you advice, but it's your responsibility to put in place the necessary measures to meet your legal obligations. The bill as drafted seems to suggest that the building safety regulator will in fact determine whether something is safe. I think that will be a cause of concern and a matter for debate amongst HSE. The regulator will also improve the competence of people responsible for managing and overseeing building work. Well, how do you do that? How do you resource that? It can only be through regulations requiring certain standards to be met. It's anticipated that this will involve scrutiny of safety cases, which will ascertain competency and wider use of enforcement powers. Well, will the bill come in? I think almost certainly there is a very wide support throughout all parties in Parliament for something to come in. Will it change substantially? I don't think so. Will it work? I have reservations. Just standing back from it, it seems to me that whilst there is clearly a desire and a need to address issues that have emerged from Grenfell, if you look at it, this is almost a melting pot of building regulations, CDM, and regulatory reform fire safety order. And I can see why you want to join up health and safety and fire safety and building control. But it's a rather ambitious way of doing it. And I'm not sure there's enough clarity as to whether it will achieve its objectives, but remains to be seen. But any of you who are involved in construction, facilities maintenance, property management, I suspect it's going to cause you some concerns and certainly a great deal of work going forward. The next element I want to deal with in terms of what's coming over the horizon is the priorities of HSE. And these were renewed very recently. And there's a focus on occupational health, in particular, occupational lung disease, musculoskeletal disorders, and work-related stress. I'm just going to spend a couple of minutes on each of those. Firstly, occupational lung disease. HSE wants to see significant improvements in preventing and controlling exposure, especially in construction, manufacturing, quarries, mines, waste and recycling, and agriculture, which is quite a wide target area. It has, again, a concern about the level of expertise given by consultants, and consultants seem to be very much in the sights of HSE at the moment. So they want to see consultants and product suppliers giving employers advice that is fit for purpose. Product suppliers is clearly a concern around PPE. And again, it's all very well HSE making those concerns, but how are they going to do that? One point worth remembering, because we're seeing it more and more, particularly around PPE in the current pandemic, and it's not directly relevant to lung disease, but it's worthy of mention. When a product is CE marked, that simply gives what's called a presumption of safety, that it meets the essential health and safety requirements, but it's a rebuttable presumption of safety. So what that means is that HSE can say something which is CE marked is still not sufficient. And I think this is an indication they may start looking behind CE marking as matters go forward. There's an intention that HSE's regulatory profile and that of local authorities should rise. They also want much more cross-industry learning about what works, which I suppose is consistent with them targeting a number of industries. They can take best practice from each. They're looking for national cross-sector leadership on eliminating occupational lung disease. And finally, they want to see the next generation of workers being educated and empowered to expect better. I think a common thread of those, apart from the specific points I've made, is how much emphasis HSE is putting on duty holders and industry themselves to put their house in order. And I think we're seeing more of that. HSE is sort of standing back saying, these are what we want to see, these are our targets. If you don't achieve it, then we'll wave the enforcement stick. Musculoskeletal disorders. Again, you'll see there, slide speaks for itself. Similar approach to that taken to occupational lung disease. Slightly different industries. Agriculture, manufacturing, construction feature as they always do, but there's logistics and transport, waste and recycling, and health and social care. They're hoping to see a shift in emphasis away from manual handling training and towards risk elimination or reduction through design. Now that, of course, is a reflection of the hierarchy of controls. You want to try and design out the risks as far as possible. It's pretty ambitious to be able to want to design out all manual handling, and training is still going to be very important. Again, a rise in HSE and local authorities' regulatory profiles. That must be an indication that they're going to raise their profile as best they can, and that I think means taking more enforcement action. Research and development on new thinking, on the risks of new flexible ways of working. HSE are very concerned about this always-on culture, that people can't get away from work. They're concerned about increasingly sedentary work and the increased use of screen-based technology. Again, the always-on culture is indicative as well of their concern about mental well-being and people not getting away from the workplace. And finally there, you'll see they want to see cross-industry learning about what works, so sharing across sectors. And finally, work-related stress. I'm not surprised to see this as a priority. When Martin Temple took over at HSE a few years ago, he made it absolutely plain that he regards mental health as part of an employer's duty. The Act, Section 2, of course, refers to health, safety and welfare, so the law is there already. And HSE do want to take action in the form of prosecution or improvement or prohibition notices to remind employers of their obligations in relation to mental health. And from that basis, as I say, I'm not surprised that work-related stress is a priority. They're expecting and wanting employers to be much more proactive in managing work-related stress through adopting management standards or some other suitable risk assessment methodology. Now, that is clearly a tool in health and safety management, but it also makes enforcement action much easier, in my view, because if you have a policy put in place by an employer or standards which are not met, then it's very difficult for an employer to say that it did all that was reasonably practicable when it didn't even meet its own standards. It's similar to the renowned rail case we started with, where they had their own fatigue policy but didn't meet it. It requires more health and safety and HR professionals trained and competent to implement and manage those standards. And increasingly, we're seeing a greater link up between HR teams and health and safety teams. Rightly, because if you've got to get health and safety right in your organization, you need HR to buy into it and to help to enforce it. Again, cross-sector learning features highly here. And also there's a recognition that preventative action can make a valuable contribution to the wider mental health agenda. So, why these priorities? I think those are the three main reasons. Work time lost through ill health dwarfs the amount of time lost due to traumatic injury. It reflects changes in work patterns, and most significantly, it reflects the wishes of the higher echelons of HSE. They are completely focused on mental health and well-being. And were it not for the pandemic, I'm sure we would have had some enforcement action around mental health in the last 12 months. Right, moving on to the final section, COVID. The legislative framework for COVID is quite straightforward. It is the Coronavirus Act 2020 and the regulations made under that act. And those regulations differ in the devolved jurisdictions in England and Wales, Scotland and Northern Ireland. Then there is a vast amount of guidance. Some of it, I don't think I'm being controversial here, not particularly clear. Some of it not particularly helpful. So what is guidance? Well, it's simply that. Failure to follow guidance does not of itself give rise to a breach of duty or a criminal sanction. Breach of the regulations made under the Act is a criminal offence, but guidance is that, simply guidance, and breach of guidance alone won't give rise to criminal liability. The interrelationship between HSWA and the guidance is something that I will look at, but in essence, HSE's view is that when determining whether an employer has done all that is reasonably practicable, if an employer is following guidance, then it's likely that it has done so. If it hasn't, then it won't have done all that is reasonably practicable. Riddle, I skirt through this. The requirement to report COVID as a dangerous occurrence arises where an accident or incident at work has or could have led to the release or escape of coronavirus. While it seems to me that that can only be in laboratory type scenarios where people are deliberately working with or on the virus. Reporting a disease where a worker has been diagnosed as having COVID-19 attributed to an occupational exposure at work, and work-related death where a worker dies as a result of occupational exposure to coronavirus? Well, going back to each of those, dangerous occurrence, I simply don't see how that can give rise to reporting obligations except where you're working on or with the virus. In terms of reportable disease, the guidance is that the responsible person, which is usually the employer, must make a judgment based on the information available as to whether or not the confirmed diagnosis of COVID-19 is likely to be caused by an occupational exposure. That is, whether or not there's reasonable evidence that a work-related exposure is a likely cause of the disease. Then work-related deaths must be reasonable evidence that a work-related exposure caused the worker's death. My question is this: what is reasonable evidence that work-related exposure is the likely cause of death? How do you go about that? Well, there's some further guidance which says the assessment of the evidence does not require a complex analysis, but there are reasonable judgments to be made as to whether the circumstances gave rise to a real risk or had the potential to cause the disease or death. Well, unless your employees are spending entire time on site in one place, not going home, and could not have been exposed elsewhere, I fail to see how that evidential standard will be met. I accept there'll be differences in the health and care sector where you are causing employees to work with individuals who know or have a reasonable belief will be suffering from coronavirus. But in any other circumstances, I would think you would have a very good argument in saying that the evidential requirement wasn't met and therefore you don't have to report it. And there are very few reports so far under RIDDOR of COVID-related conditions. And I think carefully before reporting. So, what about risk assessment and risk management? Well, there's no change in the requirements of the regulations around risk assessment. HSE says factor in the risks associated with COVID-19. If you're doing that and applying guidance, it's likely to mean that all reasonably practical measures are being taken. So that's what HSE is saying about it. Couple of other points there. Don't forget that one, you are factoring in COVID-19 to specific risk assessments. You need to look at your other risk assessments and take account of the risk of COVID-19. So lifting requirements where distancing isn't possible. Statutory testing, make sure you're keeping that up to date. There's been an issue with statutory testing houses such as Allianz and the like not letting their employees go out and do statutory testing. That's not a defence. You've still got obligations to maintain equipment even if you can't get statutory tests carried out. Considerations on re-entering premises. This may become an issue if you have another lockdown, go back in. So is fire equipment in test? Legionella, have you had a run through of pipes and the rest of it? And remember, sharing information with employers of other organisations where your employees work alongside others, such as contractors. Your coronavirus policies should be shared there as well. So, what is HSE's position? Set out clearly there. Early stages of lockdown and guidance assistance, then 6 weeks, 2 months in, threats of enforcement, and now the threat of prosecutions, first mentioned in June, but now increasingly mentioned. But what's the basis? As you know, Health and Safety at Work Act is concerned with risks at work. And section 1.3, I've set out there, says the purpose of this part, risks arising out of or in connection with the activities of persons at work. And it goes on to say they should be treated as risks, including risks attributable to the manner of conducting an undertaking, the plant or substance used for the purposes of an undertaking, and the condition of premises so used or any part of them. Well, what does a public health pandemic have to do with that definition? I think there's an argument that the risks of coronavirus do not arise out of the conducting of an undertaking by an employer. And if you look further behind the Act, then there's more support for that argument as well. The ACOP, the Pro Code of Practice to the IOSH regulations. The IOSH, as you know, applies to incident exposure to and this deliberate work with biological agents. But the ACOP says IOSH does not cover a situation where, for example, one employee catches a respiratory infection from another. This is because Regulation 2.2 specifies that IOSH only applies in circumstances where risks of exposure are work-related and not those where they have no direct connection with the work being done. Again, I ask the question, what does a public health pandemic have in terms of connection with work being done? And then I think the next quote is very telling. It's a quote from a document put together by the Advisory Committee on Dangerous Pathogens, not specifically in relation to coronavirus, it's some years ago, but it couldn't be clearer. Although your employees may well pick up infections from workmates, just as they might from their friends and family outside works, those infections are not your responsibility under health and safety law. This is because infection is just as likely to be caught outside the workplace as in it. Now, HSE's position is quite clearly stated that if you're not compliant with guidance and you create a risk to your employees from coronavirus, then you're in breach of the Health and Safety at Work Act. My question, which I leave you with, is that right? I think there's a real argument that when you look at section 1.3 of the Health and Safety at Work Act and the definition of risk, work-related risk, that HSE cannot use HSWA or regulations made under that Act as a vehicle for prosecution. Interestingly, they haven't done so yet. They have served, to my knowledge, one notification of contravention, which is on offices in Leeds, but those are government offices, and I'm sure they would not take the point against another government department that the whole thing was misconceived. That's a canter through, and I left time for questions, which I'm happy to deal with. So,
John, thank you very much for your presentation. For those of you who haven't already, you now have the opportunity to post your questions inside the Q&A box, but we already have a fair few already. So John, what I'm going to do is just, if I can in that order, throw those to you. So the first question goes back to one of your first slides, which was the prosecution of the independent health and safety advisor.
yeah.
And it's how did the HSE come to know that Mr. Wheel was giving inadequate advice? Was it the result of a proactive or a reactive inspection by the HSE?
I think, as you probably know, there's been an emphasis on halves over the last 12 months. They have been focusing organisations which are known to use percussive machinery, and it came about as a result of an inspection. The duty holder handed over, as it must, all its documentation, which included the reports from consultants, and that's how the investigation then moved from the duty holder to the consultant.
Right. Okay, fantastic. Next question from Tim. It says, do public bodies get reduced sentences due to their public duties or the services they provide?
The short answer is yes, they do. It's one of the criteria in the sentencing guideline is that if the imposition of a penalty will impact on the ability of that organisation to provide a public service, such as a local authority, then it will receive a lower fine. You need to be very careful when you're preparing a case for a local authority, because you can't just make an assumption. So, for example, if I'm acting for a health trust, a very good way of getting it across to the judge is, well, if you impose X, that means we're going to have to lose 2 frontline nurses. So you need the evidence to make it persuasive. But yeah, generally, provided your advisors get the mitigation right and get the evidence, then local authorities will be treated differently to commercial organisations.
Sure. Okay. The next few questions are regarding the proposed change in the building regulations. So, Kat,
right.
Will the building bill have an impact on tall industrial buildings, or is it just focused on residential?
Just focusing on residential at the moment.
Yeah.
Now, I'm going to sort of sound like a lawyer now. I apologise. Caveat to that is that if it seems to be working well, you can see sort of legislation creep to extend it. So certainly to new builds.
Okay. Next question from Paul is, why are the proposed change in the building regulations going to be, excuse me, an offshoot of the HSE regulator? It says common sense should dictate that there should be an offshoot of the fire service.
I can see the sense in that. I think the view is that they, as I said, I described it as a bit of a sort of melting pot of fire safety, building safety, and building control. I think the rationale behind it, and if you want to sort of spend the next lockdown, which may or may not be coming, reading, there's huge amount of research on this. The view is that if you get building control right and you get the construction right, then fire safety should look after itself. It's designing out the risk. So that, I think, is probably the rationale behind it. Of course, it's a new regulator, so the new regulator can set itself up as it sees fit and employ people from various backgrounds.
Okay, sure. Next few questions are focused on the HSE and PPE. So Lee is asking, or commenting, the HSE have stayed away from pursuing manufacturers in some cases, as it's much harder to approach. With respect to PPE, are we more likely to see companies criticised for obtaining incorrect equipment rather than the HSE going to the manufacturer, which is a much harder fight?
Yeah, it's a short answer.
Yeah.
What we're finding, I've got a few of these investigations going on at the moment, where what HSE is saying, the easy thing for HSE to do is to serve a prohibition notice, so you can't use that equipment. Because, of course, HSE only has jurisdiction within the within the UK, and a lot of the equipment is built is abroad. There are obligations on importers as well as employers, but I'm afraid the easy option is to go after the employer.
Okay, it is the easy option. Okay.
Yeah.
And on a note, a question from Paul: what action is the HSE taking over the volume of fake PPE that's currently on the market?
Right. Well, there's I think it's not just the HSE. Local authorities also have duty statutory powers. So we're seeing, particularly a lot of the London boroughs are using those powers to impound equipment and to prevent its use. HSE is issuing an awful lot of guidance and saying it will take action I think in the early stages, there's a little bit of leeway because of the complete absence of PPE, except they're regarded as absolutely safety critical. For example, if you're using sort of FFP or FF3, there's no leeway there, but other not life critical PPE was perhaps given a little bit of leeway, but I think that's going to move away. So it's a combination of HSE and local authorities.
Okay, I guess we have time for one more question. See if I can summarize. The next 3 questions are all on a similar line,
Right.
which is sort of going on your last slide. If the HSE cannot prosecute employers if they fail to follow the guidelines, how can it be enforced?
Well, there's the question, isn't it? I can see the Act can be used in those sectors, such as health sector and care sector, where you know that your employees are going to be exposed to risk and you have to take steps against it, because that is a risk which arises from their occupation. But if you're running a construction site, or if you're running a factory, I don't see how you can use the Act. Now, HSE may point to the fact that the section I refer to, section 1.3, has the words including. And I suppose they may conduct a case on the basis that, well, it is foreseeable that your workers may be exposed outside the workplace. Therefore, you must take steps to prevent employees who may be so exposed coming into contact with one another or passing on the infection. That may be right in terms of civil liability, but I think on an honest intellectual analysis of the Act, it's wrong in terms of prosecution, because it is not a risk which arises out of the employer's undertaking. It's a public health risk.
Okay, thank you. I'm afraid we have run out of time for questions. There were a fair few left there, so
if there are others you want to email them to me, James, I'm happy to sort of send it back to IOSH and you can then publish them.
Absolutely fine. Yeah. So thank you for those who are listening. Thank you for those who posed questions, and thank you very much, John, for your presentation. And I can now bring this webinar to an end. Thank you all.